The water in my bedside glass was trembling before I heard the diesel engines. By the time I reached the porch, 12 trucks and SUVs were crawling toward my farm through the pre-dawn fog, carrying security guards, survey crews, concrete barriers, and an HOA president who claimed she had legal authority to take control of my land. My name is Ethan Callahan, and I watched Rebecca Langford order bolt cutters onto the gate my father built. Then she told the convoy to proceed. If someone arrived to take your family farm, what would you do? Because what I did next started with a mistake. To understand why, you need to go back 6 months. 6 months earlier, my biggest problem was getting 40 acres of hay cut before a week of spring rain rolled across our part of Texas. Callahan Farm covered 173 acres outside a fast-growing hill country town, and I made my living raising cattle, selling hay, and repairing equipment for neighboring ranchers out of the old metal barn behind the house. That Tuesday morning, I was replacing a hydraulic hose on a neighbor's tractor when I noticed 3 orange survey flags beyond my south fence. I knew every marker on that property. Those were new. I shut off my wrench, crossed the pasture, and found 2 surveyors setting another stake nearly 60 feet inside my boundary. "Morning," I said. "Who hired you?" The younger man checked his tablet. "Cedar Vale Homeowners Association. Future Emergency Access." I looked east toward Cedar Vale Estates, the subdivision that had been spreading toward us for years. "You have written permission from the landowner?" He hesitated. His supervisor stepped over and showed me a digital work order. It listed Cedar Vale Homeowners Association as the client and Rebecca Langford as the authorizing representative. I photographed the screen, the stakes, their truck plate, and the location before asking them to stop work until they could produce permission to enter my property. They packed up without arguing. That mattered to me. Contractors were not my enemy just because somebody had sent them onto my land. That evening, I found Rebecca waiting beside my gate in a cream-colored Lincoln Navigator. She had managed commercial properties before becoming Cedar Vale's HOA president, and she spoke like somebody accustomed to making negotiations sound settled before they started. "We need to talk about the South Corridor," she said. "There is no corridor." Rebecca opened a leather folder. Cedar Vale wanted to develop Phase 4, and its preferred emergency access route crossed 34 acres along my southern side before connecting with a county road. She offered me $180,000 for a permanent easement. I read the proposed route twice. It cut through my best hay field and passed close enough to the cattle pens to turn every emergency drill, maintenance truck, and future dispute into my problem. "No." Her expression barely changed. "You have not heard the revised terms." I heard permanent easement. I handed the papers back. "My answer is no." She studied me for a moment, then asked something that seemed strangely specific. "Did your father ever discuss this property with Cedar Vale's original developer?" My hand stopped on the gate latch. Dad had been dead 6 years. "Why?" Rebecca closed the folder. "Because Patrick understood that communities change." She drove away before explaining what she meant. The next morning, I pulled Dad's property files from the office cabinet and started checking old surveys. Before I found anything useful, a certified envelope arrived from Cedar Vale's attorney. Inside was a notice telling me to cease obstructing an existing emergency access easement across Callahan Farm, and attached to it was a county recording number dated 14 years earlier, when my father still owned the land. I entered the recording number into the county clerk's online index before breakfast. The result stopped me cold. It was real. Same instrument number. Same recording date. Same general area of Callahan Farm. I drove to the courthouse anyway because I wanted the actual recorded image, not Rebecca's version of it. The clerk pulled up a 7-page document labeled Emergency Access and Utility Easement. The first page identified my father, Patrick Callahan, as grantor. The last page carried a notarized signature. That looked enough like his to make my stomach tighten. I ordered certified copies and drove straight to a local real estate attorney named Julia Bennett. She did not give me the answer I wanted. "A recorded easement can survive a transfer of ownership," she said, turning the pages slowly. "If this is valid and covers the route Cedar Vale claims, inheriting the farm would not automatically erase it." I pointed to the map exhibit. My father never told me he gave away permanent access. Then we find out exactly what he signed. Until we do not remove markers, block contractors, or give them a video they can use to portray you as interfering with emergency access. That last phrase bothered me more than the legal warning. Rebecca was not calling this a development road. She was calling it emergency access, which meant every argument I made could be reframed as me putting families at risk. By Friday, Cedar Vale had already done exactly that. An email circulated to homeowners stating that Phase 4 safety planning was being delayed by a neighboring landowner refusing to honor a recorded access right. It did not name me, but everybody knew which neighboring landowner it meant. Then Rebecca called. Her voice was quieter than it had been at my gate. "Ethan, I am not trying to steal your farm. We have 312 homes, depending on responsible planning. Then explain why your surveyors were 60 feet inside my property before anyone showed me this easement." There was a pause. "Because our engineer followed the recorded exhibit." "Did you ever see my father sign it?" Another pause. "No." That was the first honest answer she had given me. That night, Claire came home late from work wearing her bright purple, pink, and white floral blazer, her golden blonde hair pinned into its usual neat bun with one loose strand near her forehead. She found me at the kitchen table comparing Dad's old tax maps against the recorded exhibit. I told her Cedar Vale was claiming an easement. I did not tell her how aggressively Rebecca had already started using it. Claire studied me for a second. "Do you want help?" "Not yet." She nodded, but I could tell she disliked the answer. The next morning, I opened Dad's red Snap-on toolbox looking for an old boundary notebook. Behind a drawer of socket extensions, I found a faded calendar folded in half. One date from 14 years earlier was circled in black ink. Beside it, in my father's handwriting, were 6 words that made the recorded document suddenly look very different. Fire access proposal rejected. No permanent easement. I photographed the calendar exactly where I found it, then carried the whole thing to Julia instead of tearing out the page. She read Dad's note twice and set it beside the certified easement. "This helps," she said, "but it does not cancel a recorded instrument by itself." I had expected that. What I had not expected was her next question. "Do you recognize these initials?" Near Dad's note were 2 letters. HM. I did. Harold Mercer had surveyed our property for years before retiring. I found him outside Fredericksburg, living on 10 acres with a workshop full of rolled plats and filing cabinets. Harold remembered the negotiation immediately. Cedar Vale's original developer had wanted a secondary route for fire apparatus after the county raised concerns about the subdivision having limited access. Dad had considered it because he took fire safety seriously. "Patrick did not reject emergency access," Harold said. "He rejected their route." He pulled a yellowed field sketch from a tube. The proposed corridor followed the creek along the southeastern edge of the farm. The recorded exhibit in Julia's copy crossed the hay field much farther north. "That is not the line I surveyed," Harold said. My pulse jumped. "Can you prove which version Dad saw?" Harold shook his head. "Not from this. A field sketch is not the final recorded survey." That disappointment lasted less than an hour. On my drive home, Rebecca called and surprised me again. She offered $240,000 if I would sign a new easement along the exact route shown in the disputed document. "Why would I sign a new one if you already have a permanent one?" I asked. Silence filled the cab. Then she recovered. "It would clarify maintenance rights and avoid unnecessary litigation." That answer told me she was less certain than she sounded, but it also told me she still needed my land badly enough to add $60,000 to her offer. I declined. By Monday, the pressure changed shape. Cedar Vale homeowners received a notice warning that delays to Phase 4 could trigger a special assessment connected to planned infrastructure costs. People who had barely noticed my farm suddenly had money riding on Rebecca's version of the dispute. 2 residents came to my gate asking why I was blocking an emergency route. I showed them nothing. Julia had told me not to litigate through neighborhood gossip. That afternoon, a certified notice arrived announcing that Cedar Vale intended to exercise its claimed access rights the following week. Attached was a contractor mobilization schedule covering survey vehicles, security personnel, barriers, and earth-moving equipment. Then I reached the final page. Rebecca had personally signed the authorization, and beside her signature was a statement certifying that the easement was valid, enforceable, and undisputed. I had sent Cedar Vale my written dispute 3 days before she signed it. I sent Julia a screenshot of Rebecca's certification and asked one question. "Does this stop them?" Her answer came 20 minutes later. "Not automatically. Cedar Vale had a recorded instrument. Until a court ruled otherwise or the HOA voluntarily backed off, Rebecca could keep claiming she believed the easement was enforceable. Julia could seek emergency relief, but she warned me that judges did not like deciding complicated title disputes from incomplete records. "We need stronger evidence connecting your father's agreement to the correct survey," she said. Meanwhile, Rebecca was moving faster than we were. The next morning, orange contractor tags appeared on vehicles parked near Cedar Vale's clubhouse. I counted 12 from the county road. 2 security SUVs, 3 pickups, a survey truck, a flatbed carrying concrete barriers, a skid steer on a trailer. The rest belonged to contractors I did not recognize. Rebecca was not bluffing about mobilization. I drove home and installed 2 additional cameras covering the south gate and hayfield. Then I photographed every fence post, cattle gate, drainage culvert, and boundary marker along the disputed route. If something changed, I wanted a before and after record. Claire watched me label the files that evening. "You are preparing for them to come onto the property." "I am preparing in case they do." That is not what I asked. I kept typing. She reached across the kitchen table and closed my laptop. "Ethan, whatever you think you are protecting me from by keeping this separate from my work, stop. I am your wife before I am anything else." I almost told her everything. Instead, I said Julia was handling it. Claire opened the laptop again and pushed it back toward me. "Then listen to Julia." The following afternoon, Julia called with bad news. The earliest hearing she could realistically secure might come after Cedar Vale's scheduled mobilization. She was filing what she could, but there was no guarantee a judge would intervene before Rebecca acted. That left me staring at my tractor and thinking like the mechanic I had always been. If a machine was moving somewhere dangerous, you blocked it. Simple, practical, immediate. So when Cedar Vale's first contractor vehicles arrived 2 mornings later to stage equipment near the disputed corridor, I parked my tractor across the farm road and locked the gate behind it. Nobody touched anybody. Nobody threatened anybody. I simply made the route unusable. Rebecca arrived within 15 minutes. She did not argue. She stood outside the gate, raised her phone, and recorded me sitting behind the wheel. By lunchtime, a clipped version of that video was circulating through Cedar Vale with a caption accusing me of blocking a designated emergency route serving 312 homes. Then a sheriff's deputy pulled into my driveway, stepped out with a printed complaint, and asked me whether I had intentionally obstructed access that morning. That was when I realized Rebecca had not been trying to get through my gate. She had been trying to get me to close it. The deputy listened while I explained the title dispute, then looked at the tractor, the gate, and the paperwork Rebecca had given him. "I am not deciding who owns an easement," he said. "That is a civil matter. But if there is a genuine dispute, nobody needs to turn this into something bigger today." I moved the tractor, not because Rebecca had won, but because I finally understood the game she was playing. Julia used the deputy's report, my written objection, Harold's field sketch, and Rebecca's later certification to press for temporary relief. 48 hours later, Cedar Vale agreed through its attorney to suspend physical work while both sides exchanged records. For the first time in weeks, the orange tag vehicles disappeared from the clubhouse lot. Homeowners stopped showing up at my gate. Rebecca even sent a short email saying she hoped we could resolve the matter professionally. It felt like breathing room, and I used every hour of it. I met Harold again, this time at his old surveying office, where his former partner had kept archived project boxes in storage. We found a billing ledger showing that Cedar Vale's original developer had ordered 2 different route studies 14 years earlier. One was labeled Creek Alignment. The other was labeled North Hayfield Alternate. The recorded easement crossed the North Hayfield. Dad's calendar said he had rejected permanent access. Harold remembered Dad discussing only the creek route. Julia called the combination useful, but not decisive. Then the apparent victory cracked open. A project coordinator from the contractor Rebecca had hired called me unexpectedly. His name was Luis Ortega. He had seen my written objection during the records exchange and wanted to know why Cedar Vale had previously certified the easement as undisputed. I asked what certification he meant. Luis emailed me the contractor packet. On the first page was Rebecca's signature. Behind it was a title certification letter dated 4 days after Cedar Vale received my formal objection. That was bad enough. Then I noticed the orange access tags listed in the mobilization manifest. Each tag number corresponded to a specific vehicle, company, work order, and assigned task. Rebecca had created a detailed paper trail for the entire convoy. "Luis," I said, "who gave your company the easement exhibit?" "Cedar Vale Management." "Was it part of the same file as the signed document?" He went quiet. "I cannot answer that without checking our original upload." 20 minutes later, he called back sounding completely different. The signature page and the property exhibit in his archived packet had different scan resolutions and different file creation dates. I sent everything to Julia. She called almost immediately. "Ethan, stop treating this as a boundary disagreement. Preserve every file exactly as received." I looked across the kitchen at Claire. She could tell from my face that something had changed. Julia lowered her voice. "There is now a serious question about whether the document package being used against you is the same package your father actually signed." Claire waited until I ended the call. "Now tell me everything." This time I did. The survey crews, Rebecca's certification, the tractor mistake, Luis, and the mismatched files. When I finished, Claire folded her hands on the kitchen table. "Do not call my people." I stared at her. Most Cedar Vale residents knew Claire worked somewhere in state public safety. Almost nobody knew the actual job. She had spent 20 years in state law enforcement and now commanded a division within the state police organization. I was not planning to. Good, because if my division touches this because you are my husband, Rebecca gets to make me the story instead of the evidence. That landed harder than I wanted it to. I had spent weeks refusing Claire's help because I wanted to prove I could protect my own farm. Now she was showing me that restraint could protect it better than influence. She told me to preserve originals, document who supplied each copy, and let Julia determine where the evidence legally belonged. No favors. No unofficial searches. No phone calls from a command office. Julia followed the trail already in our hands. Harold's archived ledger identified 2 proposed alignments. Dad's calendar rejected a permanent easement. Luis's archived upload showed the signature page and property exhibit had entered the contractor system as separate digital files. Then Julia compared the page. Numbering. The notarized signature appeared on page 5. The disputed property description began on an exhibit labeled page 7, but the footer style changed. More important, Harold recognized the bearings. "Those are from the North Hayfield alternate," he said. That changed everything. Dad's signature might be genuine. The recorded instrument might be genuine. But the route Rebecca was enforcing could have come from a different proposal than the one Dad actually considered. We still could not say who assembled the package or when. That uncertainty mattered. I stopped trying to prove Rebecca had fabricated anything. My new strategy was simpler. Preserve every version and force the versions to explain each other. Then Luis sent one more record already referenced by the orange tags, the Convoy manifest. 12 vehicles, 12 assignments, for separate vendors. Each company had received its own copy of the authorization materials. Rebecca had spread the document trail across organizations she did not control. That evening, Cedar Vale's attorney notified Julia that the voluntary work pause was ending. Rebecca claimed the HOA had reviewed its records and remained confident in its access rights. 30 minutes later, Rebecca called me herself. For once, she sounded tired rather than polished. "Give us 60 days to negotiate a replacement easement, Ethan. Will you suspend the existing claim in writing?" She hesitated. "Only if you sign a statement acknowledging Cedar Vale acted in good faith." I said no. At 5:40 the next morning, Luis texted me 4 words. "They are mobilizing again." I stepped onto the porch and heard diesel engines gathering beyond the ridge. I did not reach for the tractor this time. I called Julia, started every camera, and opened the south gate. By 6:10, the convoy was rolling toward me through a ribbon of dust, every windshield carrying one of those orange access tags. Rebecca stepped out first. "I am glad you decided to cooperate." I decided not to interfere. Her eyes narrowed at the distinction. Behind her, Luis remained beside his company truck instead of unloading equipment. 2 other crews did the same. Rebecca noticed. "We have authorization," she told them. Luis answered carefully. "Our office received notice that the underlying access right is disputed. We need confirmation before ground disturbance." Rebecca produced a folder. She had come prepared with the recorded easement, a legal opinion from Cedar Vale's counsel, and the same certification she had signed. She was not bluffing anymore. She was betting that paperwork carrying official stamps would outweigh questions nobody had resolved yet. I stayed beside the gate and documented which vehicle entered, which company operated it, and which orange tag matched the manifest Luis had sent me. 12 vehicles. For vendors. 12 separate records of who had been told what. Julia called while Rebecca was arguing with a survey supervisor. Do not debate her, she said. The versions matter more than her explanation. That became my entire strategy. I asked each crew supervisor only whether the authorization packet they possessed was the packet their company had originally received. Some said yes. One said his office had received an updated exhibit the previous week. That caught Rebecca's attention. Updated for clarity, she said quickly. Harold's warning ran through my head. 2 alignments. 2 sets of bearings. 1 signature. Rebecca walked toward me and lowered her voice. Ethan, you can still stop this. Sign the replacement easement, and I will recommend the board increase compensation. And the old claim? Resolved privately. Meaning I say you acted in good faith. Her jaw tightened. Meaning 312 families stopped paying for your refusal to compromise. For the first time, I understood what was driving her harder than the expansion itself. If she admitted the existing claim was unreliable, every promise she had made about Phase 4, emergency access, and future assessments came back to her. She needed my signature to turn uncertainty into consent. I refused again. Rebecca returned to the cruise and ordered work to begin under Cedar Vale's claimed rights. Luis stayed put. Another contractor shut off his engine. Then the security supervisor approached Rebecca with his phone in his hand. Whatever he showed her drained the confidence from her face for half a second before she recovered. At the far end of the county road, a state vehicle had appeared. Then another. Claire stood beside me on the porch, still in her bright floral blazer, watching them approach. Rebecca glanced at her and said, "Why is your wife here?" Before I could answer, the lead vehicle stopped outside my gate, and the uniformed commander who stepped out looked directly at Claire and said, "Commander Callahan, we have your recusal on file." Rebecca looked at Claire, then at the commander, and for the first time since the convoy arrived, she stopped talking. Claire stepped away from me before answering. "Thank you. I will remain outside any enforcement decision involving this property." Rebecca recovered quickly. "Then why are state police here at all?" The commander did not take the bait. He explained that concerns had been raised about conflicting authorization documents being used during an active property dispute, and that his role was to keep the situation orderly while the relevant records were preserved and reviewed through proper channels. Rebecca lifted her folder. "We have a recorded easement. This is a civil matter. Then nobody here should have a problem documenting exactly what they relied on," he said. That changed the temperature immediately. Rebecca turned toward the contractors. "You were all provided the same authorization." Luis shook his head. "No, ma'am." He opened the archived packet on his tablet. The survey supervisor pulled up his company's copy. I used the orange tag manifest to match each vehicle to the packet behind its assignment. One company had the North Hayfield exhibit attached to the signed instrument. Another had an updated exhibit Rebecca had described as clarification. Luis's archived file preserved separate upload dates for the signature page and the property exhibit. Harold's old project records identified the North Hayfield as an alternate alignment, while Dad's calendar recorded his rejection of a permanent easement. None of those facts alone answered every legal question. Together, they destroyed Rebecca's claim that everyone had been relying on one clear, undisputed document. She changed tactics. I did not create 14-year-old county records. I relied on what Cedar Vale had. It was a better defense than denial, and she knew it. Then I asked the question she had been avoiding. "If you believe the old easement was unquestionably valid, why did you offer me $240,000 to sign a new one?" Rebecca looked toward the homeowners gathering beyond the county road. "To clarify maintenance rights." "And why did you require me to say Cedar Vale acted in good faith before you would suspend the old claim?" Her face tightened. "Because you were threatening this community with unnecessary litigation." Luis spoke before I could answer. "Ms. Langford, our company needs written direction. Are you personally instructing us to proceed under the current packet despite the documented dispute?" Every camera was running. Every contractor was listening. Rebecca stared at the open gate she had fought 6 months to control. Behind her sat the convoy she had assembled to prove Cedar Vale had authority. In front of her were 4 vendors holding versions of that authority that did not match. Claire said nothing. Neither did the state commander. Nobody rescued Rebecca from the decision. Finally, she reached for the authorization folder, and whatever she chose to say next would determine whether that convoy moved another foot onto my farm. Rebecca looked down at the authorization folder, then back at Luis. "Suspend field operations," she said. The words were barely louder than the idling engines. All vehicles returned to staging. Nobody celebrated. Engines shut down, barriers stayed strapped to the flatbed, and the convoy that had entered my farm under Rebecca's authority began leaving under her order. That decision did not settle the easement, but it ended her attempt to create control on the ground before the documents could be tested. Julia moved immediately. Using the conflicting contractor packets, Harold's archived route records, Dad's calendar, my written objection, and Rebecca's certifications, she obtained an order preventing Cedarvale from using the disputed North Hayfield route while the easement record was reviewed. The document trail finally answered the question that had haunted me since the courthouse. Dad had negotiated emergency access, but the North Hayfield description Cedarvale had enforced could not be established as the route he had approved. Cedarvale stopped asserting that route against Callahan Farm and released its claim rather than continue defending the conflicting record. Rebecca's problems did not end there. The board reviewed her $240,000 replacement offer, her undisputed access certification signed after receiving my objection, and the mobilization she authorized while contractors possessed inconsistent exhibits. She was removed as HOA president, and Cedarvale absorbed legal and contractor costs tied to the failed operation instead of passing them to me. The board later returned through counsel with something Rebecca should have started with, a negotiation. I agreed to a narrow emergency-only easement near the creek, close to the alignment Harold remembered, with written limits, compensation, maintenance terms, and no development traffic. I had never wanted 312 families left without responsible emergency planning. I wanted my consent to matter. Months after that first morning, I stood beside the repaired south gate, holding one of the orange contractor tags I had saved. 12 vehicles had carried those tags onto my property, and the manifest behind them had helped connect 4 vendors to 4 versions of Rebecca's paperwork. Claire stood beside me in her bright purple, pink, and white floral blazer, her golden blonde hair pinned into its neat bun. Rebecca had believed Claire was simply my wife who worked somewhere in public safety. She never knew Claire commanded a state police division until the final confrontation, and by then Claire had already recused herself so completely that nobody could credibly claim her authority had decided the dispute. Her badge did not save Callahan Farm. Her judgment showed me how to stop trying to overpower Rebecca and start making every claim answer to evidence. I hung the orange tag above Dad's red toolbox and looked through the open barn door at the hay field the convoy had come to take. They arrived with 12 vehicles to make their authority look bigger than mine. They left because the truth was bigger than all of them.